Welcome everyone to this update on data protection. So Claire and I will be talking you through some recent developments and also some of the key compliance things you should be thinking about from a data protection perspective. So we're going to cover the key data protection obligations and documentation, information security and data breaches, and then finish off by looking at subject access requests and complaints, everyone's favorite topic. But before we dive into that, just when sort of, as Joe mentioned, the GDPR has been around for 4 years now, and it's gone by in a flash. Just when everybody sort of felt they'd got to grips with it, it's about to be changed again. So some of you may have seen from the Queen's speech, the data reform bill will be put before Parliament shortly. And this is on the back of the government's consultation on reforming data protection law, which they did last year. And in a nutshell, it seems very much the driver is sort of reducing the amount of red tape associated with data protection, so making it a bit leaner, making it a bit easier to sort of to use and exploit personal data, but obviously in a way that still sort of comes with checks and balances and complies with the data protection principles. It'll be interesting to see what the bill looks like once it's published, but I think it's more going to be a sort of a minor tweak here and there rather than sort of a wholesale scrapping of the current rules, but something to keep an eye on. Okay, so I'm now going to hand over to Claire, who's going to talk about documentation.
Thank you, Andrew. Okay, so I thought it would be useful to do a bit of a recap of the data protection basics. I'm conscious that some of you listening to this will be quite proficient in data protection law. Some of you might be brand new to it, maybe trainee solicitors, for example, that kind of thing. So it would be kind of useful, I think, just to recap, as I said, the essentials. One of the misconceptions often about data protection law is that the GDPR and the Data Protection Act are the same thing. I do see this floating around the internet sometimes. They're not. They're actually two separate pieces of legislation. So in today's webinar, Andrew and I will be covering both, and they very much work hand in hand. You can't really consider data protection law without considering both pieces of legislation. And then there are other pieces of legislation as well, such as the Privacy and Electronic Communication Regulations, or PECR for short, that will also impact on your firm's compliance. So data protection law is principles based, which is why I've put a list of principles on this first slide. These principles are contained in the UK GDPR, Article 5, if you wanted to look them up. And one of the things I think is most challenging about data protection law, at least when you're first starting to think about it, is the fact that it is principles based rather than prescriptive. And there will be a lot of situations where your law firm comes across a compliance issue where you do have to look beyond the strict letter of the law. This isn't really a black law letter exercise often, because it is principles based, which involves a judgment call. And that's why the Information Commissioner's Office guidance, so the Information Commissioner's Office is the regulator of information law, and their guidance often puts the meat on the bones of a lot of these things, because it is principles based. It's not hugely prescriptive in a lot of areas. So just quickly to run through these principles, which I'm sure will be familiar to most of you listening to this, because this really is everything centers around these principles, really. So the first principle is that personal data is collected and processed transparently, fairly, and lawfully. And the next slide actually will be to do with transparency in a bit more detail. The second principle is that you only collect personal data for specified legitimate purposes, and then don't go on to use them in a further way that's incompatible with those purposes. This sometimes is referred to as function creep. So you've got to kind of be quite careful about the uses for which you put personal data, and you've got to kind of think about these things at the outset. And then we move on to making sure that personal data is both adequate, relevant, but not excessive. I refer to this principle as being the Goldilocks principle. It's not too hot, it's not too cold. So you don't want to collect too much personal data, but neither do you want to collect too little, so you can't actually do what you need to do with it. And then the fourth principle is very self-explanatory. I think that you must make sure that take reasonable steps to make sure it's accurate and also kept up to date. And then for law firms in particular, I think the fifth principle can be a bit of a It's an interesting one. It's a bit of a struggle sometimes, which is that you shouldn't keep personal data for longer than is necessary. And again, this is a judgment call really on how long you should be keeping things. Often it's about thinking about what are your insurance requirements, what are your SRA requirements around these types of things when coming up with that period for how long you're going to keep personal data. And then lastly, but very much not least, it's the requirement to keep personal data secure. And Andrew will be going into more detail about that particular requirement later on in the webinar. So transparency, I'm sure you're all familiar with things called privacy notices, transparency notices, privacy policies. They're all the same thing, essentially. There's different names for them. This is an example of where often the term used is not actually contained in the law itself. So the law around transparency is contained in Articles 13 and 14 of the UK GDPR. They're subtly different. So Article 13 is about when you collect the personal data from the individual directly, whereas Article 14 is about where you get information about someone from a third party. So you can imagine Article 14 is particularly relevant to law firms. There are slightly different requirements. So if you collect it from the individual themselves, you have to provide them with this transparency information when you collect the data. If you get it from a third party though, so Article 14 says that you should provide it within 1 month or at the first time that you communicate with the individual, with the data subject, whichever is later. Privacy notices are really so important because often when we're dealing with things like complaints, whether it be for clients, whether it be complaints to a law firm or to us, having something in a privacy notice or transparency notice, whatever you've chosen to call it, is really helpful in managing the expectations of the person who's maybe complaining about your data protection compliance. It's a really good way of managing their expectations. And also it's really helpful to be able to point to something in your notice that says, actually, we did tell you we were going to do this with your data. So, you know, takes the wind out their sails a bit if they're complaining about it. I've mentioned a layered approach on the slide, and this is essentially about not providing a really kind of dense and long document all of the time. That's not always appropriate up front. So the privacy information that you need to provide is information about why you're using the data, what rights people have in their data, what your lawful basis is under the GDPR for using the data, where you're getting it from, who the recipients are, that kind of thing, who you might be sharing it with. So you can imagine that in a law firm context, that's quite a lot of information to provide to someone. So to make it more user-friendly, the Information Commissioner's Office used the term layered approach, which means that you can give people the high-level information up front and then provide them with a link to access the full document that might be published on your website, for example. And this very much ties in with data collection forms, because if you're asking someone to fill out a form, maybe it's a new client as part of your onboarding process, you could provide them on the form itself with some key information and then link to your full notice that's on your website, for example, as to where they can find further information if they want to. So we still have to actively provide the information in the sense of giving them a link to where they can find it rather than just assuming they'll hunt it out themselves. But that layered approach, it's just a lot easier for the individual. It's more data subject friendly, essentially. I should say there are certain exemptions around the transparency requirement, some of which are quite relevant to law firms. So if you are ever concerned about having to be transparent with someone about the fact that you've got their personal data, it is worth looking at those transparency obligation exemptions, some of which are in the UK GDPR, some of which are in the Data Protection Act. Okay, so I mentioned a moment ago that we need to demonstrate our compliance. So those 6 principles that I went through, in addition to complying with all those principles, a kind of a sea change when the GDPR came in is that you now have to demonstrate your compliance. So it's not good enough just to comply with the law, you actually have to show how you're complying with it. And this links in with another GDPR requirement, which is called data protection by design and default. Now, data protection by design is about baking in data protection into all of your practices. So think of it really as an essential ingredient into the cake of running your law firm. One kind of top tip I would have is that I find when organizations get into trouble around data protection, it's often because staff members don't know to go and speak to the data protection lead about something before they start doing something new with personal data. And one of the key things about accountability and data protection by design is that you are thinking about data protection up front at the start of using personal data in a new way. And I do often get exasperated data protection officers who are advising come to me and say, I don't know why my colleagues don't speak to me sooner. So I think one of my top tips really is make sure that fee earners, secretaries, whoever it is at your law firm knows and can approach your data protection lead when they start doing something new. Might be a new marketing initiative, might be starting to use a new piece of software for data protection, sorry, a new piece of software to do something, legal tech, that kind of thing. Do think about data protection up front, because it's so much easier to comply with data protection if kind of people haven't started or already kind of got halfway through the project before they think about, oh, data protection, might think about that too. And that's really about culture and about training. Now, data protection compliance is not about ticking boxes. You might hear quite a lot where people complain that data protection is a tick box exercise. The Information Commissioner's Office guidance on accountability explicitly explains that it's not about ticking boxes. A lot of it is a judgment call, and a lot of it is also risk-based. So the measures that you need to put in place to comply with your data protection obligations should be proportionate to the risks. So information security, which Andrew's going to talk about later, is one of the high risk areas. So the measures that you should be putting in place to keep information secure should be really, really robust. Whereas there might be other areas of data protection compliance where you don't need to do quite so much. So it's about proportionality. And any organization, law firm, or one of your clients, otherwise maybe smaller organizations that you're advising, they don't have endless resources to spend on data protection compliance. So we do need to think pragmatically about these things as well. And I think that's where proportionality can be really, really helpful. Think about where the risks lie and focus there. There are certain documents that are explicitly required under the UK GDPR and the Data Protection Act. Now, some of these documents are actually going to potentially be removed under the government's reforms of data protection law. But the two I just wanted to flag on this slide in particular are a record of processing activities under Article 30 and an appropriate policy document regarding special category data. Those are a couple which are actually explicitly required under data protection law. And you might remember I mentioned about 10 minutes ago that often data protection law is not that prescriptive. It's a judgment call, and you have to kind of think about how you're going to comply with it, what works for you. But those are two documents that are explicitly required. We'll move on to the next slide now, and I'm going to talk you through some of the things that I find that law firms really should have in place. Like, very few of these are explicitly kind of mentioned in data protection law, either pieces of legislation. But when thinking about what measures you should be putting in place, both organizational measures, so staff training policies, and technical measures, you need to think what's appropriate for you. Think about what you are doing as a law firm with personal data and what you think you might need. Now, in my experience of advising law firms and also other organizations of all shapes and sizes, the ones I put on the slide are really the main areas of data protection law that you should be focusing on. And these are where your policies and procedures, your written policies and procedures, should also be focused. The first thing to mention is the essential requirements that your staff need to know about. The thing about data protection, similar in some ways to money laundering, is that it is something for every member of your law firm to know about, because we all deal with personal data on a daily basis when doing our jobs. Now, I often see data protection policies which are very long-winded, they're very kind of legalistic, and I appreciate, the people reading your policies are probably going to be lawyers themselves, but that doesn't mean that your policies shouldn't be practical. They should be. They should absolutely be user-friendly and practical, because nobody wants to go through pages and pages of documentation about how to comply with data protection law. What they want to know is how can they do their job and also comply with data protection law. So think about how to make your data protection policy for staff, your guidance for staff. How is that going to be practical? Use lots of examples. I'm a big fan of examples. Also a big fan of case studies in policies as well. Kind of give examples, really worked out examples are really useful sometimes. I'll move on now to information security, because that really is quite an essential aspect of data protection law, as Andrew will mention later. So information security could be included in the same policy as your big data protection policy. I often find it works better as a separate policy because shorter policies are generally more user-friendly, and I'm all about making these things user-friendly and practical so people actually read them. Information security should cover things like home working. So in the pandemic, obviously, we all worked from home, that had information security implications. So your staff should be given guidance on information security when working from home. Think about your IT team are likely to need to input into your information security policy. So it's a data protection lead plus IT thing normally. Also practical things around physical security as well, because whilst I think a lot of us are almost paperless now, I know a lot of law firms aren't. And even though my team that I work in at VWV is pretty much paperless, we all print things out from time to time, whether it be a long email from client, whether you want to proofread a contract, that kind of thing. Think about how you are advising your staff members around physical security as well as electronic security. Like I said, your IT team should input into this policy too, and you might find guidance from the National Cybersecurity Centre also helpful when developing your information security policy. Data breaches. So this obviously is something that all law firms dread, but they do happen from time to time, and sometimes they're simply, human error. Sometimes they're more serious. Think about what you will do in the event of a data breach. Having a policy or procedure that you can turn to when it's kind of panic stations time is so helpful in just allowing you to think clearly about what you need to do. So I really recommend that law firms and other organizations as well have a data breach procedure that they can turn to if something bad does happen, that talks you through the ICO reporting requirements, reminds you to report to your insurers if you think a claim could be intimated, reminds you about, who to speak to about reputation management, who to speak to about HR issues that could be kind of caused by this data breach. So just having this document in place is really, really helpful. And if it does end up going to the ICO and the ICO do end up investigating, the more you can do to show that you were prepared for this eventuality and that you have thought about it, the better. Because the ICO do, like I said, this is a legal requirement to be able to demonstrate your compliance in this area. So let's think about how we can kind of make hay while the sun shines, as it were, before the worst happens. Think about what documents you can put in place now to make life easier if you do ever suffer a data breach. In terms of retention, I mentioned that you shouldn't keep things for longer than necessary. It's often helpful to have a retention schedule which sets out for how long the firm will keep different types of personal data for. And that can also be linked in your privacy notice as well, because that is one of the things you should be telling individuals how long you will keep their data for. Marketing as well. Again, I would expect your marketing team to have their own policies and procedures, and also to have their own bespoke training around the data protection requirements and the privacy and electronic communication requirements as well around sending out marketing communications. If you use CCTV, which I know a lot of law firms will do, whether it's on the outside of your building or inside, do think about having a CCTV policy which sets out kind of how you've thought about your data protection compliance around CCTV, who can access the CCTV, how you're keeping the CCTV footage secure, what you will do if the police ask for CCTV footage, that kind of thing. That should all be kind of laid out in your policies and procedures. And then last, but very much not least, a key part of demonstrating your compliance is doing data protection impact assessments where required. So these assessments are required where you are about to start, or before you start doing processing of personal data in a way that's likely to lead to high risk to individuals. And the ICO has some quite useful guidance on this. And the ICO have actually created a list of 10 areas where they say you should absolutely be doing a data protection impact assessment. So like I said, that's part of this kind of bulwark of documentation that you should have as a law firm. But also make sure, as I mentioned a moment ago, that staff members know when to speak to the data protection lead, because it's all well and good you having one person at the firm who is an expert in data protection law, or even having a team that's an expert in data protection law. Because personal data is used by everybody, you do need a basic level of understanding amongst all of your staff members to be able to comply.
Great, thank you, Claire. So I just want to finish off this section by looking at some principles, something to think about when sharing personal data outside of your law firm, and in particular in relation to suppliers. So there's been a huge shift really for the past 20 years, but I think it's really been accelerated recently, particularly in light of COVID, of sort of law firms outsourcing the provision of services to third parties, services that are sort of critical to your business, for example, printing and scanning, payroll, online data rooms, and payment services, and so on. And when entrusting a third party with your personal data, there are, in most cases, in data protection terms, the third party is going to be your data processor. because they'll be handling the data on your behalf and on your instructions. And when you use data processors, there are some things that you need to keep in mind. The first is that you need to make sure that your contract with the data processor contains the mandatory provision set out in the GDPR, in the UK GDPR. And this covers everything from information security to disclosure to the processor being required to assist you with things like sort of access requests and so on. And even if there's never a data breach, if those provisions aren't included, then you're in breach by using that data processor. And I will often review contracts on behalf of EWV, and it's quite incredible the number of times the essential wording is missing. So it is important to check. If there is a data breach at the data processor's end, and if you haven't sort of complied with these steps, the ICO will also look to yourselves as well. So you can end up being liable and culpable for a breach by one of your processors. So it's just important to get these steps right. It's not sufficient to simply sort of have the contract and then forget about it. You've also got to carry out due diligence in the processor just to make sure that they are complying in practice. And I think really, again, I would just be focused on information security. So for example, the sorts of things you should be checking, is the data encrypted at transit and at rest? What sort of data centers do they use? Is the data sort of stored somewhere reputable? Are they certified to a recognized information security standard and so on? So plenty of things to think about. Ideally, you would want the data to stay in the UK, but if the data is going overseas, if it's going to a country that doesn't have an adequacy finding, such as the United States or China or Brazil, then you need to take an extra step for compliance. In practice, this means making sure that your contract incorporates either the standard contractual clauses for international data transfers, or alternatively, the ICO's new International Data Transfer Agreement, which is set to replace the SCCs. In terms of sort of specific issues to law firms, it's also just worth thinking about your SRA requirements. So the code gives the SRA a right to certain information held both by your practice and also by suppliers who provide critical services. And with that in mind, it's just important to make sure that there's a contractual provision in your contracts that give you the right to request information from your suppliers in line with SRA requirements, just so that you can sort of back to back the SRA's expectations with your contractual rights. Then just finally on this slide, another sort of trend over the past few years is law firms are sort of branching out into other services. So here, for example, we have a HR consultancy. We also provide training and other things through VWV+. And it's just important, just if this applies to you, it's just worth thinking about whether there are any data protection implications. So for example, you should make sure that your privacy notices explain how you share personal data within your different group companies. You should be thinking about things like who would be responsible for responding to a subject access request. If you are a joint data controller, you're required to have an arrangement in place, which in practice would sort of usually mean having some form of written agreement that sort of sets out within the group who is responsible for which aspect of compliance. Okay, so I'm now going to move on and talk about information security. And as ever, this really remains the area of greatest risk in terms of data protection and compliance. The vast majority of ICO fines have come about through data security breaches. The vast majority of claims, data protection related claims, I think have their origins in security issues as well. So what are we required to do in terms of information security? Well, the UK GDPR says we have to do two things in essence. We have to make sure we have in place appropriate technical measures and appropriate organizational measures to safeguard personal data. So technical measures are things such as network security, using encryption as appropriate. Organizational measures really cover some of the points that Claire mentioned a few minutes ago. For example, staff training, having the written policies and so on. These requirements are sort of unpacked slightly. So you've also got to be thinking about encryption, making sure that data is backed up. And you're also required to sort of have ongoing testing and assessment. So for example, bringing IT experts to carry out penetration testing on your systems, and just thinking about those sorts of issues. I think it's really interesting. The the GDPR and Data Protection Act, it's a fairly sort of lengthy piece of legislation combined, and yet the most important bit on data security is kind of limited to a couple of paragraphs, which just really demonstrates Claire's point that it's very much a principles-based regulation. So I had to think about what I sort of felt would be the biggest risks for law firms, and I think there's really three things in particular. So phishing and ransomware attacks, email issues, and also issues and risks around people working from home or when people work, when people are out and about. So just be thinking about what you can do to mitigate against all these sorts of risks. So for example, with phishing and ransomware attacks, one of the things that we do at VWV is our IT team will send out fake phishing emails to staff to try and sort of trip people up. And it's actually a really, really effective way of sort of getting people thinking about compliance and sort of helping to identify anyone who might not fully have got the message around sort of not clicking on suspicious looking links. Happily, no one in the detection team has fallen for this yet, because that would clearly be very, very, very awkward internally if that ever happened. The best one we've had was we had a colleague who joined us. We got an email inviting us to connect with him on LinkedIn, and it wasn't a real link. Again, it was a fake one sent out by IT. And because this is someone new, you kind of expect them to contact you, and it all looks official. People just clicked on the link when in fact what you should do is, if you get a LinkedIn request, is you should log in through the browser and connect that way, rather than sort of clicking on a link in the email. In terms of emails more generally, we've been talking about sort of external attacks, but people make mistakes. People send emails to the wrong recipient. People attach the wrong document. This all happens. So just be thinking about what you can do there. We, for example, have the software that will sort of prompt us to double check email addresses before the email is sent. And it also has red flags. So if we're sending an email to a sort of a publicly available platform such as Google or Hotmail, then it will sort of, it'll sort of flag it in red, so just so we can be absolutely sure that we're sending the email to the right person. You're just as responsible for what your staff do at home as when they're in the office in terms of data protection compliance. So just make sure that people are sort of, people understand the do's and don'ts when working from home. Are people allowed to print at home, for example? Can I take papers home? What are your expectations on sort of, what people can and can't have with them at home and when they're out and about? I just thought it'd be helpful as well just to sort of talk about a recent ICO fine. So this was the ICO recently fined Tucker's solicitors. What had happened was Tucker's were hacked. They had an awful lot of information encrypted, and some of the information was exfiltrated and published on the dark web, and it related to some pretty sensitive stuff. For example, information about criminal convictions, and there was some health data in there as well. And the Tuckers were fined £98,000 in the end. And I think it's a really interesting case study on sort of what the ICO's expectations are and the sorts of things that we should be thinking about. And I would definitely suggest that you ask your IT colleagues, your colleagues with responsibility for security, just to read the ICO's decision in its entirety, because it's quite illustrative. But the sorts of things the ICO picked up on are, for example, they didn't have multi-factor authentication for all remote access, so people could access the system just with the username and password. And so it's just important to make sure that you've got the extra layer of security so that even if passwords are compromised, then the systems shouldn't be. The ICO also found that there was a delay in implementing a critical patch. So there was a vulnerability was identified, the vendor or the software issued a patch, but I think it took them 4 months or so before the patch was actually applied to their systems, and it's possible that was what allowed the attacker in. There was also a failure to encrypt the data. The ICO made the point that you can get specific court bundling software with encryption capabilities, and that's apparently commercially available and not particularly pricey. So the ICO picked them up on that as well. What's also interesting is the ICO will lean very, very heavily on the guidance and expectations produced by other government bodies. So, for example, they often quote from guidance from the National Cybersecurity Centre, and they will sort of benchmark when sort of thinking about taking enforcement action for a breach. They'll often sort of quite closely scrutinise how an organization's compliance against the National Cybersecurity Centre guidance. And so I would sort of, if you haven't already done so, just sort of pay quite close attention to the NSC website and just sort of make sure that you're sort of complying with all their guidance. But there's all sorts of sort of helpful resources and tools. For example, they got something that will apparently give you an alert if your system's been compromised. They can sort of help you sort of spot vulnerabilities in your email platform and so on. So there's plenty of tools and resources. So another change over the past few years is it's becoming easier, I guess, for individuals to bring claims for data protection related breaches. So many years ago, it was actually quite difficult for someone to bring a successful claim if their data rights had been infringed. And that was because they had to demonstrate financial loss in all cases. So if they'd suffered distress, for example, they couldn't claim for that unless they'd also suffered some form of financial loss. Things started to change, so the courts decided that you could actually claim for distress without having to show financial loss. And so there's been a gradual sort of shift to an environment that's much more sort of friendly towards claimants. It kind of, I suppose, reached a high noon with the Court of Appeal's decision in the Lloyd and Google litigation, where the Court of Appeal said that you could claim compensation for loss of control of personal data without actually having to show any distress or financial loss, and that potentially sort of would open the floodgates to sort of the sorts of ambulance chasing claims for very, very minor data breaches that I'm sure we're all we can all imagine. Happily for controllers, the Supreme Court in Lloyd and Google found that you couldn't claim compensation for loss of control of personal data by itself. It had to be some form of damage, and so that was a helpful decision. The case was decided under the old Data Protection Act, and there's some debate about how the principles would apply to the GDPR, and that's because the GDPR gives loss of control as an example of damage. So potentially there's a risk that whilst loss of control by itself isn't recoverable under the old Data Protection Act, it could be under the GDPR. But personally, my view is that the courts would sort of follow a similar approach, and I think the mood music and I are very much more in favour of sort of clamping down on the sorts of claims that are becoming popular. A good example of this actually involves a case involving this law firm. So we sent an email to the wrong recipient. The email contained a bit of personal data about someone. It wasn't particularly sensitive or confidential. The unintended recipient immediately deleted the email and told us that they'd done so. Nevertheless, the data subjects brought a claim against us, and for various breaches, including under data protection law, and we got it struck out. And I think it's just really illustrative just to read out what the judge said. So he said, "We have here a plainly exaggerated claim for time spent by the claimants dealing with the case and a frankly inherently implausible suggestion that the minimal breach caused significant distress and worry or even made them feel ill. In my judgment, no person of ordinary fortitude would reasonably suffer the distress claimed arising in these circumstances in the 21st century. In the modern world, it is not appropriate for a party to claim, especially in the High Court, for breaches of the sort which are frankly trivial." So a really helpful judgment that should hopefully sort of bring some of the more adventurous data protection claims to an end. Just to finish off on this slide, another area where this has sort of played out is around website cookies. So we've had a number of clients who have received letters of claim alleging that cookies have been set in breach of PECA. And in a nutshell, in order to set cookies, you need to get consent, which is why you see all those sort of pop-ups on websites, and also provide information about the cookies that are set. And we had people suggesting that they'd suffered distress on the back of sort of analytics cookies being set without consent and so on. But these appear to have dried up since voting Google, which is good news. But I think it just illustrates, though, it's cookies compliance is fairly straightforward. So so it's a good example of sort of low-hanging fruit. If you maybe just check your website, make sure that you've got the consent banner, make sure that you've got the you explain what the cookies do, because even if any claim is at fairly low value, that the hassle and cost in dealing with it can be quite significant. Okay, so I'm going to hand over to Claire, who's going to talk about subject access requests.
Thank you, Andrew. So yes, everybody's favourite topic, subject access requests. This is going to be a bit of a whistle-stop tour because of the amount of time we obviously have for this webinar. But this is something that we definitely wanted to cover because I've definitely seen an increase over the last 2 years, actually, in the number of subject access requests being made. It's a right that's been around, actually it's a right that predates the GDPR. It was in the 1998 Act as well. It might have even been in the 1984 Act, I'm not sure. And essentially, it's a fundamental right of data protection law that people have a right to know what personal data an organization processes about them. Anybody can make a subject access request. It doesn't have to be made in writing. That was a change when the GDPR came in. It used to have to be in writing. And you can no longer charge a fee either. You used to be able to charge a tenner to deal with the subject access request. That's kind of gone away. Broadly speaking, that's gone away. So anybody at your firm can receive a subject access request, and it doesn't need to be labeled as a subject access request. It is simply a request for a copy of the personal data that your firm holds about them. It can be broad, it can be specific, and we'll get on to narrowing down requests in a moment. But the key, I think, for this first slide is please include this in your training for your staff members on data protection compliance, because as I said, anyone at your law firm can receive one of these, and they need to know that they shouldn't be dealing with this themselves. They should be passing it to your data protection lead, your compliance team, for example, to deal with, because they can be quite complicated to deal with. Also, there's often a background of subject access requests to a subject access request, which tends to be a little bit contentious, not necessarily full-blown litigation, but it might be that somebody's fishing for information that they are thinking about either using against you, or more likely they're thinking of using against your client. So they are quite tactical, quite strategic as well, and quite complex to deal with. So please make sure that your staff members don't think that they should be dealing with them themselves. They should be passing it to a senior member of staff, preferably your data protection lead. So initial considerations. The first thing you want to be thinking about when you receive one is, do we need to go back to ask for evidence of identity? If it is someone that you've been dealing with regularly and you are satisfied the request has genuinely come from them, you don't have to ask for ID. You should only ask for ID if it's reasonable to do so, and you should only ask for the amount of personal data you need to satisfy yourself that the person is who they say they are. So, for example, if you receive a subject access request from a current staff member, you're unlikely to need to ask for ID because you have that ongoing relationship with them. Whereas if you get a request from somebody that your law firm has never dealt with before, or has only dealt with maybe a few years ago, or they're using a different email address to the one that they normally use to correspond with you, that would raise some alarm bells with me. And I'd be thinking that that actually would be reasonable to go back and ask them for ID. The next thing we would normally think about is whether you need to go back to them and ask them to clarify what they are seeking. So the guidance says that if you process a large amount of data about someone and it's not clear what specifically they're asking for, you are allowed to go back and ask them to clarify their request. They are still entitled to come back and say, actually, you know what, I want everything. But in that scenario, your obligation is to carry out a reasonable search. And it's often best to make it clear to the individual when you go back for clarification that if they don't specify what they want from you, that your obligation is only to carry out a reasonable search. So the more they can help you, the more you can help them, as it were. The deadline is an interesting one. So it used to be, and I mean, many years ago, it used to be 40 days, which is always quite straightforward. It's actually more complicated under the GDPR. So the initial time period for responding is 1 calendar month. And that calendar month either starts on the day that you receive the request or on the day that you get their ID if you've asked for ID. If you've gone back to ask them for clarification, the clock pauses but doesn't restart. So if you get a request, maybe you think about it for a few days, you go back and ask them for clarification. Let's say they come back and they take 4 days to get back to you with their clarification. You can add on that extra 4 days to that first 1 month. If that kind of 1 month, or the 1 month plus a few days possibly, ends on a weekend or a bank holiday, you have until the close of play on the next working day to respond. So that's the initial time period. For complex requests, you can extend the time frame by up to a further 2 months. But to do that, you have to notify the requester with reasons why their request is complex and letting them know you're going to be extending the time frame. And you have to do that within the first 1 month period. They can't, you're not asking for their consent to do that. It is kind of a unilateral thing, but you do have to provide them with reasons for why you're extending the time period, reasons why the request is complex. So searching for personal data, this can be one of the most difficult bits of dealing with a request, actually. It's searching, particularly if you hold a large amount of data about someone. I'm thinking in particular the ones that tend to be the hardest to deal with, or where it's someone who is either employed by you or used to be employed by you. They're sometimes the most tricky. So your obligation is to carry out reasonable and proportionate searches. What I always say is, when you're doing these searches, bear in mind what is the definition of personal data. So just as a recap, personal data is information that relates to a living individual from which that individual can be identified or they are identifiable indirectly. So it doesn't have to include somebody's name. So let's say that Andrew used a nickname for me and I made a sub access request. It would be reasonable to search for that nickname as well as my full name or my name. So think about what the definition of personal data is. But if I've simply been CC'd into an email, it's probable that that email isn't going to contain my personal data. The fact that I've just been CC'd into an email is not my personal data. So think tactically and think strategically about where you are most likely to hold the individual's personal data. You are not obliged to search in every possible conceivable location where that personal data might be held. It is about reasonableness and proportionality. So you can think logically. I think law firms are actually an advantage in this area over other organizations that I advise, because law firms tend to have very good document management systems in place, unlike some other organizations. And this document management system is likely to make it easier for you to search for personal data about someone, particularly if there's someone who's been involved in a particular matter, because emails about them were likely to have been stored in a particular place. But do think about that when designing your document management systems or refreshing them, that kind of thing. Do think about how you would deal with a SAR at that point. Next slide, please.
Claire, can I just jump in there? We've had a question come up in chat, so before we move too much further away from that. The question is, should the person requesting the data give the reason why they are making the request?
No, so that's a really great question though, really great question. Often you can infer it, but they do not have to tell you. It's a purpose blind right. It's a fundamental right of data protection law. It can be helpful to think about the context and the background, though, as to why they might be making the request when thinking about where you might hold the personal data they're seeking. But no, it's not something they have to tell you about. I should also add as well, Joe, that there is no obligation for the person to put that. I've mentioned that the request doesn't have to be in writing. I see some organisations say that they ask requesters to fill out a particular form. You shouldn't be doing that. You can have a form if you want, and it can make life easier sometimes, but you can't force the requester to fill out a form or give you any reasons for their request. So the next slide, again, it's not an absolute right. So this is reassuring, particularly for law firms, because there are lots of exemptions in the Data Protection Act that you can rely on. This comes back to the point I made at the very, very start of this webinar around we need to be thinking about both the GDPR and the Data Protection Act, and they're not the same thing, but they do work together. So the right to make a subject access request is in the GDPR, the UK GDPR, but most of the exemptions are contained in the Data Protection Act. So you need both pieces of legislation, which can be a little bit frustrating. I've put a selection of exemptions on this slide. There are gazillions, well, not gazillions, but there are quite a few exemptions in the Data Protection Act, which is really, really helpful. Legal professional privilege is an exemption that's going to be particularly relevant to law firms, but there are others as well. And the legal professional privilege exemption has a second limb to it as well, which is worth looking into around information obtained in confidence by a legal advisor. So worth having a look at that exemption, which I think is not section 19 in Schedule 2, I think, paragraph 19. The mixed personal data exemption is the one that comes up the most on all subject access requests that I advise on, because it's really rare to have an individual's personal data completely isolated from information about other people. So often you might not be able to give the requester their personal data without also revealing information about somebody else. Where this is the case, we think about what I call the mixed personal data exemption, or the information about other people exemption, which states that you can either ask the other individual for their consent, but there's no obligation to do that. And often it wouldn't be appropriate or reasonable to do that. Without their consent, the question is it reasonable to give the requester that information about the other people? And again, this is only where you can't give the requester their personal data without giving them information about other people. We're not talking about, let's say you have an email and there's a paragraph about one person who's the requester and there's a completely different paragraph about somebody else. They're not entitled to that paragraph about the somebody else just because it's in the same email. The right is limited to the personal data, not to the document that contains that personal data. So we're talking very different from litigation disclosure rules here. You can therefore extract the personal data and put it in a new document if you would like to. So I've gone a bit of a tangent there, but I think it's relevant to mixed personal data, because often we do find it's easier to extract personal data rather than redacting. I put negotiations exemption on there as well, because that might be an exemption you want to look into, and references provided in confidence. If you're getting a request from an employee or a former employee, that could be relevant. That is simply a snapshot of the available exemptions. The key points around the exemptions are, don't apply them in a blanket-like fashion. I'm afraid it is a painstaking process to go through and prepare the documents for disclosure, because you do have to think about every single line of what you were going to be disclosing and whether you can rely on an exemption to withhold the personal data from the individual. Like I said, the exemptions are quite complicated to apply, but the ICO, the Information Commission's Office, has relatively helpful guidance on them. But obviously, Andrew and I are here if you ever want to chat anything through, anything particularly complex. I'm conscious of time, and Andrew's got another section as well on complaints. So just some top tips, I think, on preparing the disclosure now. Please make sure it's overseen by somebody senior. Preparing a subject access request disclosure is not an admin job. It should be overseen by somebody senior. Keep a record of what exemptions you rely on. This is important not only for your accountability requirements that I was talking about earlier, but also if someone makes a complaint to the ICO. Also, obviously, keep a record of what you send to them for your own records. In addition to a copy of their personal data, they're entitled to certain supplementary information, typically information about sources, so any available information as to source, recipients, how long you're going to keep the data for, that kind of thing. If that is contained in your privacy notice, the ICO say it is fine to provide your privacy notice to them, but do make sure that privacy notice does actually contain the information it needs to, the supplementary information. And last but not least on this slide, coming back to information security again, please make sure you send it securely. The risks around, as we will mention in a moment, the risks around subject access requests are relatively low because the ICO is quite pragmatic on them, but a data breach is a whole different kettle of fish. So please make sure you send the request securely. There are certain situations where you can refuse to respond to a request. Those are if it's manifestly excessive, if it's manifestly unfounded. There is a high threshold for those two things, and I would strongly recommend looking at the ICO guidance on those points before you rely on those exemptions. You have to tell the individual that you are relying on that exemption with reasons. You also have to let them know about their right to complain to the ICO and to seek a judicial remedy if you're relying on either of those exemptions to refuse to respond. Just to give you an idea about what might be manifestly excessive and what might be manifestly unfounded. I'll start with unfounded first. If somebody makes a subject access request and then turns around and says, I'll give you £500 if I withdraw my subject access request, will you give me £500? That's a manifestly unfounded request because they're not genuinely wanting to exercise their right. They're just doing it to make a quick buck. Manifestly excessive, if somebody has repeatedly asked you over and over again for the same personal data, that will be manifestly excessive. They're really quite high thresholds though, and they rarely come up. I think I've only ever advised clients to rely on them less than a handful of times, and I've advised on hundreds of subject access requests. So the risks around subject access requests. People complain to the ICO about them quite a lot because it's free to complain to the ICO. And as I mentioned a moment ago, normally when someone makes a SAR, there's normally a slightly contentious background to it, and they've got nothing to lose by complaining to the ICO. They can also apply for a court order. This is rare. I've rarely ever seen this. Most people just go down the ICO route because it's free. Should also flag, and this is something you'll want to flag to your staff as well, is a criminal offence to withhold personal data or destroy it or amend it to prevent the requester being given what they're entitled to, unless you had a reasonable belief they weren't entitled to it. So this is an offence, though, that I'm not aware actually the ICO have ever prosecuted under, but it is there in the Data Protection Act. I think it's around section 169 of the Data Protection Act, I think it is. So those are the risks, but as I said, the ICO are quite pragmatic around subject access requests. I'm not really aware of much enforcement action being taken, and where enforcement action is taken, it's where it's generally been quite a bad breach of data protection law on the subject access request front. However, data breaches, sending it securely, that's really where the risk lies. So disclosing too much or disclosing information insecurely is often the risk area here rather than disclosing too little. But obviously do remember that criminal offence around if you are withholding things from them, got to make sure you've got a reasonable belief that it wasn't disclosable. Next slide, please. And I think I might be passing over to Andrew for our very, very final section.
Thanks, Claire. And I can see for those of you still with us, we're at 1 o'clock, but Andrew just has a couple of slides left now on how to help prevent and deal with complaints.
Thanks, Claire. Thanks, Joe. So sometimes somebody might complain about your data protection practices if they genuinely feel that you haven't got something right. But equally, we see and advise in so many cases where somebody has got a wider dispute or grumble with an organization, and they sort of try and sort of crowbar in a data protection issue as sort of leverage as part of their wider dispute or wider complaint. But it's, I suppose, just important just to be able to do everything you can to sort of head off complaints, deal with them appropriately. So make sure that your staff are trained on data protection, just so that we absolutely minimize things going wrong. And also so that staff can spot data protection issues, because sometimes it's not immediately obvious that a complaint has a data protection angle to it. Make sure that your staff training is backed up by your policies and procedures. Make sure that your privacy notice fully sets out how you use and share personal data. So quite often you can deal with a complaint by sort of explaining to the person that you're allowed to do so, and then referring them to the relevant part of your privacy notice, which just explains how their data is used. Okay, so in terms of dealing with complaints, I think the approach and strategy should really very much depend on your relationship with the individual. So if it's somebody, clearly you would maybe have a different approach if it's somebody that you want to sort of have an ongoing relationship with. I personally, I think where people go wrong with these sort of data protection complaints is there's sometimes a temptation to get sucked into sort of protracted and lengthy correspondence with the complainant, about data protection, about your data protection compliance. And you can find some cases where no matter how much assurance you provide, the individual just comes back with more and more questions and more and more sort of insinuations, allegations that you're not compliant. If you're confident around your practices, don't be afraid to invite the complainant to go to the ICO. As Claire said, the ICO is a sensible and pragmatic regulator, and it may be that the extra assurance from the ICO that to the complainant that you've handled things appropriately is kind of what they need in order to sort of to bring things to a conclusion. If you do decide to invite them to go to the ICO, I would just maybe set out all the points that you want to make regarding your compliance in one email, because really you're writing for the ICO's eyes rather than from the complainants. So that's everything I wanted to cover on complaints. I'm now going to hand over back to Joe to finish off.
That's great, thanks Andrew. And I'm going to ask Emma to pop the feedback poll up in a second as well. We have one further question in the chat box, Andrew Clare. If a former employer provides an employee reference which is false and inconsistent with former employee records, is there any relief under the GDPR beside a civil claim in the court? So a false reference, does the GDPR assist in any remedy on that front?
Yeah, the short answer is yes. So if by providing a false reference, they've processed the personal data in breach of the data protection principles, then yes, and that might be the case if it's inaccurate, for example. And it may also engage with the general fairness principles as well. So yes, in theory, absolutely, there could be a data protection angle to that as well.
And would that apply to, would that relief be available to the new employer or to the employee?
It would be available to the employee as the data subject, which is just subject to one very interesting caveat, which is probably a bit too much detail for this session. But the GDPR says that any person can claim damage for a breach of the GDPR, and the Data Protection Act said individual, or words to that effect. And so it's not clear if that was a mistake or whether the GDPR intends that companies, third parties, corporations, employers can also claim for data breaches. I haven't seen it addressed in any detail anywhere, so it's almost like it's something that no one spotted. But the intention is probably that the claim that the right is just relates to the data subject, rather than saying that the employer can claim as well. But it's just subject to that one caveat.